Next case is Florida Farm Bureau versus Freeman.
May it please the court. My name is Elliot Shurker on behalf of Florida Farm, the petitioner. This court established in Higgins that pre-class...
How much time would you like to rebuttal?
I apologize, Your Honor. May I have 3 minutes for rebuttal? This court established in Higgins that pre-class certification discovery is permissible if limited to matters relevant to class certification and if not unduly oppressive and burdensome. This principle was applied in Higgins to allow the discovery of the defendant title insurer's files only, quote, as necessary to establish facts relating to class certification. The court suggested, for example, a random sampling of the files. Now here the plaintiff has unfettered access to all computerized claim files, which will show pertinent matters such as the cause of loss for pre-certification review.
Counsel, below, did you, excuse me for interrupting, but did you ask for a random sample at all?
No, sir. We objected to the untrammeled allowance of either interrogatories, which the court ultimately took back on reconsideration, and of depositions on written question of all 30,000 policyholders. That's what the plaintiffs asked for, and that's what the court gave them. And we stood in firm objection to that. Respectfully, it's the wrong side of the courtroom for us to try to formulate their discovery for them. This is what they asked for. This is what they got. We objected to it as burdensome. We objected to it as unnecessary. And quite frankly, as far as we're concerned, Your Honor, as I said, they have had unfettered access to our files. They have unfettered access to the physical files. And in their own certification motion, I believe it's page 26 of the amended motion, which is tab 5 of their appendix, they say that there's no individual issues and that all the information that's required is in Florida Farm's files. That's their position. We say, fine, that's your claim. You have our files. You don't need any discovery at all. Now, what we say is what the law is, because that's what Higgins said, Your Honor. When you wrote that there can be pre-certification discovery, that is within the control of the trial court, it's reviewed for abuse of discretion, but that it should be limited. If they want to come back with a limited request for discovery, we'll fight that out if and when they do. But what's before the court right now is an order that has no constraints at all, has no limitations at all, except that 30,000 of our policyholders are going to receive notices of deposition. And question number one, and I'm quoting from trial counsel now, at appendix 6, page 18 at the hearing before the trial court is, do, quote, you want to enforce your rights by obtaining a mold test, or will you be more inclined to join a class action to do that, or would you be more inclined to hire an attorney to pursue a $500 claim against Florida Farm? Even the trial judge who initially granted this motion to allow interrogatories said to plaintiff's counsel, well, we all know what the answer to that's going to be. So what they're doing is they're turning the superiority prong of the class action certification test under Rule 1.200 into a plebiscite. They say we need to prove superiority, so we need to tell you how many people really want to be in this class action. That's far beyond anything that's contemplated in Higgins and carried not even to its logical extent, taken on its face based on this record and based on the trial court's order. The same could be done in any class action case. It's not unique to their negative value class action claim in this case. It would be any class action case. If superiority is a plebiscite, then every class plaintiff who files a class action complaint is entitled to take the same kind of discovery as a matter of right of every single class member to determine whether or not they wish to join in the class action. That's not Florida law. The leading case, of course, is the 3rd District's Bobinger decision, which we relied on in our papers. The court recognized that under Gulf Oil, the First Amendment allows a class plaintiff or class counsel to solicit class members, to openly solicit class members, as this law firm did in their advertisement for more class members. It allows for direct mail contact with class members. But what it does not allow, what it does not permit, is using class discovery as a tool for soliciting new class members. And the court was very specific in its holding under Head Note 2. Given that Bobinger is entitled to solicit for additional parties to join as plaintiffs in the pending action, Bobinger may do so only by using names and addresses obtained through Bobinger's own independent efforts, as, for example, through public records. The court continued. The discovery materials may be used within the parameters of Gulf Oil and is otherwise related to the merits of the underlying controversy. Customer names and addresses learned in discovery from Deltona may not be used for solicitation of legal representation. The court quashed the order because it had no constraints and allowed for that. At a bare minimum, at a very bare minimum, Bobbinger demands that the plaintiffs not be able to use any information learned in discovery to solicit additional class members. And there's good reason for that rule. As the 11th Circuit noted in the Jackson case, it can cause serious and irreparable harm to a defendant to allow that sort of solicitation of class membership. Consider my client, consider Florida Farm. What the plaintiff wants to do is essentially to send a letter. They're going to call it a deposition notice, but it's a letter to all of those 30,000 policyholders, and that's their number, 30,000 policyholders, saying, Florida Farm cheated you, or we filed a lawsuit saying Florida Farm cheated you. You're entitled to $500. You want to join us in this class action? Now, considering the relationship between an insurer and its policyholders, the effect of that kind of communication is obvious, and that's what the 11th Circuit recognized in the Jackson. The trial court has allowed the plaintiff Freeman to establish a basis, on the ostensible basis, of establishing a basis for class action, to solicit class members. And that's what you're doing when you say, I want to show the court. Now, they say they want facts. They don't want to solicit class members. And I don't think we can split that here, or even stand it up for that matter. And what you're doing is...
Are you just guessing that they're seeking new class members? Are you just guessing that they're looking to seek new class members?
That's the only thing they're doing. They're sending out a piece of paper saying, do you want to be a member of this class? Now, whether you call that seeking new class members, or you call that proving superiority, and I'll get to that in a minute, the effect is exactly the same. They're asking for a show of hands among our 30,000 policy owners of who wants to be a member of the class. That has exactly the same effect. Now remember, they have full access to our files. They have full access to all the information.
Isn't it their burden, though, to prove superiority?
That's correct. But superiority is not a plebiscite, Your Honor. Superiority is not a question of how many people want to join in a class action. Otherwise, you would have that kind of discovery in every single class action. Every plaintiff would be allowed to do that. Now, once the class is certified, and notice goes out to the class members, well, the defendant's there. That's where you are. But this is even before a class is certified, sending out class notice. The time for plaintiffs to opt in or opt out is when class notice is issued, not when you're still in the discovery stage. But they're moving the opt-out stage, and they're moving it to an opt-in, if you will, which Florida rules don't recognize at all, to the front end of the process. But let's talk about superiority for a moment, Judge Clark, because that's what their excuse is. And I'm not looking for any hidden motives here. I'm just calling the thing what it is. When you ask somebody, please tell me in writing whether you wish to be a member of this class, you are soliciting class members. There's no other way, there's no other thing that you can call that. You can call it anything that you like, but that's what it is. But let's talk about superiority. We cited the Kia case, the recent decision from the 3rd District in June of 2008 in our papers. It's at 985 Southern 2nd, 1133. And when the court talks about superiority beginning at page 1141, what it says is, to find superiority, a court must find all other methods of resolving the issues in a case to be inferior to a class action. That's what superiority is about. It's not about how many folks you're going to have in your class. That's what numerosity is about. Numerosity is how big the class is. And of course, they can establish numerosity, as they say, from our claim files. They know how many policyholders there are. They say there's 30,000, and they want to send these deposition on written question, no distinction between that really and interrogatories, to all 30,000. Now, Kia was a negative value case. Judge Shepard's opinion notes that there's about 3,000 folks. There's about $1,000 apiece. It was a FDUCA case. But the court didn't focus on how many would wanted to be in the class. The court analyzed how big the class was going to be, how many folks probably had claims, and then looked to what you always look to, was what's the best way to try this case. And of course, what the court looked to was whether or not these were individualized claims. It didn't matter whether there were 200 claims or 3,000 claims, and it didn't matter whether there were $1,000 or $500 or a couple of $1 million. What mattered was how they were going to try the case, and because they ultimately determined in Kia that these were individualized issues for each plaintiff, then of course under classic class action analysis, the court said no, this shouldn't go forward as a class action. We are so far ahead so far behind, however you want to look at it, of that inquiry in this case. They filed their amended motion for class certification. We've not yet responded, and we're talking about discovery. So while they say we need a showing of hands, there's not a single case in Florida or under Rule 23 that says superiority requires a plebiscite and a show of hands.
What is the if you could just capsulize for me, what is the evidence of irreparable harm in this? I mean, I understand your argument on the merits.
Just as in Bobinger, Your Honor, once you unleash this spring, I mean, this isn't a cat coming out of a bag, Your Honor. This is a pride of lions coming out of the bag that's going to every 30,000 policyholders to say that, do you want to join a class action against your insurer? The commercial relationship, the fiduciary relationship between an insurer and an insured would necessarily be negatively affected by that. They would be sending out the notice that they would only be entitled to send out if they satisfied class certification. And they're taking discovery, the discovery process, which this court has said is limited, which every court that's addressed the issue has said cannot be used to solicit class members.
I see your point on that, but is that not an issue that could be raised on appeal from the class certification order if, in fact, the class is certified, or indeed on appeal from the final judgment?
Judge, I don't see how I could tell you that the class should not have been certified because they got discovery. And if we win class certification, but the notice has already gone out, the harm's done and it's unreviewable. You could win class certification. I suppose you could say, you could argue on appeal that if the trial judge allows this discovery and you were not to grant certiorari, and the court said that, well, look, there's 30,000 people who joined the class, superiority is shown.
Well, it sounds like what you're saying, though, is the only real evidence of irreparable harm is they might erroneously get to a decision of class certification.
Not at all, Your Honor. Not at all. The harm is the same. If we win.
Is it the fact that it's burdensome? It's a lot of money?
Well,
I mean, that's not irreparable injury.
I think it's burdensome, but this isn't, they're not taking discovery from us. They're taking discovery from 30,000 class members, which is burdensome to the court, and it's going to take a long time, and will keep us probably from getting to a class certification hearing, the speedy requirement of such notwithstanding. But no one's ever going to be able to review whether this was right or wrong unless it's reviewed now. If I wait until somebody comes forward and says something bad about me as a result, and I were to come to you and go to the trial court, then trial court would say, I've already ruled on this, Mr. Shirker, and I'd come before this court and you'd say you got another order saying the same thing. You're about 30 days, 60 days, a year too late. This is the only window in which we have, just as in Bobinger, to review this. And the irreparable injury doesn't have to be a lot of injury. It just has to be something that can't be addressed. And the cases have recognized, and I commend the Jackson decision to the court, that if you send out that kind of communication, you necessarily have a negative effect. Now, if it's folks out there who are suing some company for some injury, that's one thing. That's bad. These are our policyholders. According to the plaintiff, a lot of them may not even know that they have claims yet. So this is going to be introducing a new element into the insurer-insured relationship that we have no control over at all. And no way to fix. And I think that's essentially the definition of irreparable, and we believe that the harm is there. I reserve what I have left for rebuttal. Thank you very much.
May it please the Court, I'm Jason Richards. I represent the appellee, Phyllis Freeman. Judge, I think you started out and you hit it on the head, which is the first issue that has to be proven is irreparable harm. And when we look at what courts have defined as irreparable harm, we look to the Supreme Court's case in the Martin case. In that case, they said irreparable harm are the kind of things such as the republication of a libelous statement. They said there's physical danger to individuals. There's privileges involved. Their privacy interests that rise to the level of trade secrets, work product, or information about confidential informants, information that could get out that could lead to the undermining of some criminal investigation. That's irreparable harm. Their claim of irreparable harm is widespread publication that a lawsuit exists. That's what they're saying. We don't want our policyholders to know that we have been sued over a mold issue in the policy, because we don't want our policyholders to go out there and start suing us over $500. They don't want us to...
Counsel, apparently at least two other districts in Florida have found irreparable harm simply by virtue of the fact that you would be possibly soliciting additional class members by using discovery. I think that's the Bobinger case and the Rissi case. And isn't that basically saying that that type of discovery is irreparable harm for the reasons that the petitioner here said?
If my intention was to solicit. They're premising this on the assumption that my intention of going out there and talking to their policyholders is to solicit new class members. There's no evidence I intend to go out and solicit new class members by engaging in this discovery. That's what they want to. We talked about the black hat earlier. They want to paint me in a black hat and say that's my intention. I have a class member. She already exists. I don't want other ones. I'm fine. It's always great to have more than one, but my intention is not to go out there, talk to these policyholders and say, hey, by the way, wink, nod, would you like to join the class? Because I need more than one. That's not my intention. It never has been my intention. The record is clear. I've never said that was my intention. That's what they want this court to believe, to think that that's the reason for their irreparable harm. And it doesn't exist. I've never said that. That's not my intention.
What is the reason for the discovery then?
Is to prove our elements of class certification. We have to prove several elements. We have to prove commonality, typicality, superiority. We have to prove all those things. And the superiority element, I'll go ahead and skip to that. Is the class treatment the superior method of proceeding in the case? That's what the court kind of has to look at. So are individual claims sufficiently large enough to justify the expense of conducting a separate action? And looking at that, as the Manual for Complex Litigation says, it would be helpful for the court to know the extent to which individual potential class members have an interest in joining a class or pursuing a separate action.
Would you concede that the trial judge could have allowed you to get this information by tailoring this order much more narrowly than this? I mean, it seems to me to defeat the whole point of class litigation if you're going to go and have if you're going to depose every class member. Why not just have, 1,000 separate suits?
Well, the trial judge, I'm not sure he could have gotten more narrow than he did. I tried, in my initial motion for third-party discovery, well, I said I want to conduct interviews with the policyholders and maybe send some interrogatories because I don't want to burden them. I don't want to call them into a deposition site. I don't want to be traveling all over the state conducting 30,000 depositions. I can't conduct 30,000 depositions. I'm one person. But the fact is that I wanted to proceed in that angle and say, let's send some interrogatories to them under 1.320.
Yeah, but you can't send interrogatories to a non-party.
Exactly. And they said, no, he can't do that. That's against the rules. He's got to follow the rules. He can only proceed by taking third-party discovery through 1.310 or 1.320. That's depositions or depositions by written questions. And I said, okay, well, that's fine. If that's what I have to do, then that's what I'll do. But their insinuation that I intend, it's absurd to say that I intend to go out and take 30,000 depositions in 5 months. That's preposterous. What I said, and I actually resent the insinuation that I intend to take every class member's deposition. I said in my motion for third-party discovery, and they know this, so I'm not sure why they're saying it. I said, consistent with the manual's recommendations, and this is in the record, plaintiff proposes to limit the scope of her third-party discovery by propounding interrogatories, rather than conducting depositions, to a selected number of existing and or former policyholders sustaining water intrusion and or mold damage as a result of one of the hurricanes in 2004.
That's what I was referring to.
That's it.
What number is that? I mean, what?
The number is whichever is reasonable in the 5 months I have to conduct discovery.
Because it seems to me you could get the same information just by getting a representative sample of the class.
I could. I could. And I intend to do a self-imposed representative sample. But the issue here is not whether, in Higgins, the court said it is the trial court's discretion. They shall consider whether or not to impose a sample, to limit it to a sample of proposed class members. It's not a requirement. So when you look at the issue, you say, is it irreparable harm? Let's just assume there is for the sake of argument. Then you look and you say, did the trial court commit fundamental error by not invoking or not imposing a representative sample rather than allowing the plaintiff to go out and depose all 30,000? And when you look at Higgins, it's not mandatory. Higgins says the trial court should consider it. If the trial court exercised the very discretion that this court gave them You can't say what he did was fundamental error. It's that simple. So that's you have to back up from there. As far as the waiver argument, Judge Clark, I think you may have touched on that. The fact that they did not ask, that the petitioner did not ask for a random sample in the trial court, and he just admitted they didn't, means that they can't re-argue that on appeal because it wasn't raised below. We raised that argument in our brief. We let the court know this is a new argument. It may be a crafty appellate argument, but it wasn't an argument that they argued below, and they hired appellate counsel. They came up with this argument, but this is new. It was not squarely addressed below, and the law is if an issue is not squarely addressed below, you can't raise it for the first time on appeal. And that's what they're doing. They're raising it for the first time on appeal because they believe this is their best shot at getting a reversal. And maybe that's crafty appellate work. I'm not sure, but I'm not an appellate lawyer. But the fact is they have waived their argument because they did not raise it below. They did not ask for this relief. They didn't say, Judge, if you're going to allow us, if you're going to allow the plaintiffs this discovery, would you at least limit it to 30 policyholders? They didn't ask for that. So they didn't get it. They got exactly what they asked for. They got that the plaintiff and her counsel is limited to conducting discovery in the manner provided for in the rules. That's what they got. They should not be heard to complain now.
Counsel, what does the trial judge's order mean by limiting the questions to facts relating to class certification?
What he meant is that if I'm going to let you take some discovery of third-party policyholders, since the law is that you shouldn't take discovery of the merits, you should limit it to pre-certification discovery issues relating to class certification.
I understand the law, but he wasn't specific about what questions couldn't be asked, was he? He just had a general statement of what the law requires.
Correct. He said I basically have to follow the law. I can't. I have to limit my questions to issues related to class certification. So, commonality.
Did he address at all some of the questions? Apparently, the record reflects that you at least provided the first a series of questions that you might ask in an interrogatory.
I didn't. Those are just questions I came up with. Those are questions I typed up 5 minutes before the hearing. Those are off the top of my head. There are certain questions that I need to establish for class certification. These aren't written questions that I gave the court. These are questions that I typed up and went, well, here's what I'd probably ask. If I got to establish commonality, I need to know whether or not the person had water intrusion, because that's what my plaintiff had. I need typicality, predominance. I need to ask certain questions tailored to get at the class certification elements I have to prove. And that's what I'm trying to do. I'm not trying to go out and get more plaintiffs. I don't want more plaintiffs. I'm not trying to go out and get into the merits of every individual plaintiff's policyholder's claim. I'm trying to prove my elements of class certification, and they don't want me to do it. The trial judge said I can do it. You can go out, take discovery. It's got to be limited to class certification, but you can go out and you can do it. And I said, fine. They got exactly what they asked for, and now they're complaining that they got what they asked for and they don't like it. And I would also mention this. He mentioned that it's irreparable harm to have widespread publication of notice to these policyholders. I would notice in a coverage dispute, the policyholder and the insurance company, there's no fiduciary duty there. In a coverage dispute such as this one, where we say they didn't provide coverage for what they're supposed to provide coverage for, the parties are antagonistic. That's, I think, a 1972 case. But the parties, policy insurers and insurers, have always been antagonistic. They've always been at odds with each other on a coverage dispute. There's no fiduciary relationship there in a case like this one. Based on Higgins, Your Honor, Your Honors, which this court, which my judge, Judge Swanson, was obligated to follow. I know he considered these issues as far as whether or not to limit sampling, limit the discovery to a sample of proposed policyholders. I know he considered it because the defendant cited it in a brief. I know he considered it because at the hearing, the defense counsel handed him a copy of Higgins and said, read this, Judge. He sat there and read it. So he knew what the law was, and I even mentioned some constraints at the hearing. I know he considered these issues. The fact is that he read the case, he knows about Higgins, he knew what it stood for, and he knows that it stood for the fact that a court has discretion in limiting third-party discovery to proposed policyholders. He exercises his discretion by not imposing any such limited sample, but the fact he exercised his discretion, as Higgins allowed him to do, doesn't mean that he committed a fundamental error of law, which is one of the two prongs you have to look at. Unless the court has any other questions, I think I'll stop.
In case there's any lack of clarity, it is not our position that this order should be reversed in favor of some sort of random sampling. It's not our position that this order should be reversed in favor of any form of limited discovery. It's our position that this order, as written, does not comply with Florida law. This is what they asked for. This is what the trial judge gave them. If they wish to reformulate a request and if this order is quashed, then we'll deal with that when the time comes. But the court cannot authorize untrammeled written depositions of every single class member as requested, as Judge Van Nortwick, that was the question that's in the record. That's question number one. The court cannot do that because under Bobinger, class discovery cannot be used to solicit class members. And I wrote down counsel's own words when he was addressing the court. He said he was going to ask about their interest in joining the class. If that's not soliciting class members, I don't know what is. That is, in other words, these two things cannot exist in the same time and space. You cannot have a rule that prohibits the use of discovery to solicit class members and discovery that asks potential class members whether they want to be class members justified under that rule. It's about that simple. That's what's wrong with this order. In Bobinger, the court said that a bare minimum, and in the Fourth District case following Bobinger, the Stewart case, you have to strike from the order, you have to add to the order that discovery cannot be used to solicit class members. How can you authorize written depositions that ask potential class members whether they want to be class members and strike from the order anything that would allow discovery to be used to solicit class members? That is what this discovery is. It's not about Mr. Richards' intentions. It's not about anything like that. I don't know what his intentions are. It doesn't really matter what his intentions are. That's what the trial court authorized. And while classic discovery under Higgins can be easily limited that way because you're taking discovery of substantive issues as to certification and as to class membership, when the order authorizes discovery that asks, quote-unquote discovery, the primary question of which is, do you want to be a class member? It can't stand. Thank you.